On the 9th of August this year, in accordance with our rules, following the issuance of the arrest warrants, the Prosecutor General of Lebanon reported that the Lebanese authorities had been unable to locate the 4 accused, and as a result of that, just 2 weeks ago, the President of the Special Tribunal for Lebanon invoked what we call advertisement provision, where the indictment has basically been made public with the exception of certain information which we felt necessary was to be kept from the public at this point in time. We've moved to this advertisement provision. These 2 rules together lay the groundwork for what is probably the most significant legal difference between the STL and the other tribunals. Namely, our statute and rules of procedure do allow for us to conduct trials in absentia, which has not been the case with respect to any of the other modern international courts and tribunals. But in order to get to that step, we have to do really 2 things. We have to have a period of at least 30 days where the Lebanese authorities are offered or required to make arrests. Following the end of that 30-day period, we have a further 30-day period of this advertisement. That's not to say that the Lebanese authorities can't continue searching for and attempting to make arrests, but we are now in the second of these 2 30-day periods, at the end of which will be most likely towards the end of September some kind of hearing on whether or not we should move to a trial in absentia. And if that's so ordered, then the 4 accused will be assigned defense teams. We will then move into the phase of disclosure, pretrial disclosure, preliminary motions will be filed, etc. So that's really where we are with respect to the Hariri case. Now, just very briefly, we also have potentially, or our statute, Article 1 of our statute, which was annexed and incorporated by reference in Security Council Resolution 1757. The jurisdiction of this special tribunal extends really to 3 distinct categories of cases, if you will. One being the Hariri case, which we've just talked about. Number 2, other attacks that occurred in Lebanon between 1 October 2004 and 12 December 2005, if those attacks are found by the pretrial judge to be connected and similar in nature and gravity to the attack against former Prime Minister Hariri. That's category 2. Category 3 are other attacks that occurred in Lebanon after 12 December 2005, if also found to be connected to the Hariri attack, but subject to a further agreement between Lebanon and the United Nations and with the approval of the Security Council. Let's leave aside for the moment the 3rd category. With respect to the 2nd category, those cases which are found by the pretrial judge to be connected and similar in gravity and nature to the Hariri attack that occurred between 1 October 2004 and 12 December 2005. Recently, the Office of the Prosecutor has made submissions on 3 such cases, the cases involving Marwan Hamadeh, the case involving George Howie, and the case involving Elias El-Mour, all 3 of whom were fairly prominent Lebanese politicians. Mr. Howie was killed in the attack against him. Mr. El-Mour and Mr. Hamadeh both survived the attack, although other people, either in their vehicles, bodyguards, or bystanders, were killed in the attacks targeting the 3 of them. Just earlier this month, we had a ruling from the pretrial judge ordering the deferral of those 3 cases to the jurisdiction of the tribunal. So we have made, obviously, some kind of demonstration to the pretrial judge, which I can't go into in any detail at all, but we have made, the pretrial judge has made a finding that those cases are connected and are similar in nature and gravity, and has ordered the Lebanese authorities to defer those 3 cases to the jurisdiction of the tribunal as well. So we are now currently focusing some work on trying to develop those cases, get them indicted, and hopefully get them joined with the Hariri case, obviously, in terms of judicial resources, and because they are connected, we would like to pursue one trial that involves as many of these cases as we possibly can. Very quickly to answer some of the questions that Mark Drumble put earlier, the biggest challenge, when you indict people who are part of Hezbollah, I think that's probably challenge enough. We also suffer, as virtually all of these courts and tribunals have, with the issue of arrest. The likelihood of any of these individuals being arrested is very, very small. The likelihood of any of them voluntarily surrendering themselves to the tribunal is even smaller. So those are some of the biggest challenges we've had. In terms of biggest achievement and accomplishment, obviously we're still in the very early stages. We're just still learning how to walk here, in effect, compared to the ICTY and the ICC. But I think just the fact that we were able to get an indictment through the confirmation process was a relatively significant achievement. I know when I left the ICTY, more than one of my colleagues thought I was absolutely insane to be jumping to the Special Tribunal for Lebanon. But I think that the fact that we've been able to get both that initial indictment and to get at least 3 of the connected cases connected and deferred is pretty significant. So I will just very, very quickly, with respect to the students that are out there, I echo a number of the comments that some of my colleagues have made. I particularly like the comment that James made at the beginning. One of the most important things that I'm looking for when I hire, and I've sat on a number of hiring panels, both at the ICTY as well as at the STL, is I'm looking for people who have criminal litigation experience. We do have a small number of lawyers who do mainly legal research, drafting memos, etc., but we are a criminal prosecution office. That's what we do. You would be surprised when I advertise a post requiring 5 years of experience, I get applications from people with 10 or 12 or 15 years of experience. So when I have a post that requires a P2 kind of entry-level post with maybe 2 to 3 years of experience, I'm getting people with 7 or 8 years of criminal litigation experience. This is not necessarily the message students like to hear. Go out, go to work at the U.S. Attorney's Office, the District Attorney's Office, the Public Defender's Office. I don't really care whether you defend or prosecute. I want to see that you understand how a criminal courtroom works. If you're one of many law students who are saddled with a huge amount of debt, go to a firm, but go to the litigation department and complex litigation. If it's civil litigation, I want to see that you know how to handle a case that's going to take 3.5 years if it ever goes to trial and has 52,000 documents in it, because that's a lot more like the cases we deal with than any other kinds of cases on the civil law docket. So get that experience, get in a courtroom, keep coming to meetings like this, and those are the best ways, I think, to ultimately get hired here by one of the tribunals.
Great. Thank you very much, Daryl.